first defendant?
My Lord, T.A. Bozimo for the first defendant.
For the first, right?
Okay, for the first. Yes, holding the brief of F.J. Edema.
No, hold on, I've not started recording. Let me be sure. What of the third defendant? Third.
The third defendant.
Sorry, second defendant. For the second. Okay. You will call the case now and start. We want to start the proceedings now. Yeah. Jim, call the case. Remove your face mask.
Resume today, Tuesday, 9th November 2021. Before His Lordship, resume today, Tuesday, 9th November 2021. Before His Lordship, Honorable Justice F.I. Kola Olare. Suit number NICN IP 90/2013. Between 1. Omole Heyeme, 2. Mr. F.A. Ogunwale, 3. Mr. M.B. Akineki, 4. Mr. A.T. Akande, 5. Mrs. Ukoye A. 6. Mrs. B.A. Ishmael, 7. Mr. Samson Alade, 8. Mr. Idris Shake Adekunle, 9. Ms. Temi Lolawa E. Oyewo, 10. Mr. Taiwo S. Adeodu, 11. Mr. Alabi Adodu, 12. Mr. S.O. Adebayo, 13. Mr. Lawa Jumo, 14. Mr. O. Olugbemi, 15. Mr. K.A. Fasena, 6. Mr. Adeku Ishmaela, 17. Mr. J.K. Awolowo, 18. Mrs. Jegide Taiwo, 19. Mr. Aru Adegoroye, 20. Mrs. Lorita Omomie, 21. Mrs. Ogunbumi Felicia O. 22. Mrs. Annie Abidumi Aro, 23. Mrs. Akemi Joseph O. 24. Mrs. Balogun AA, 25. Mrs. Benson.
26. Mm-hmm. 26. 26.
26. Mrs. Erenle Dasola D. 27. Mrs. Akinrodemi Hannah M. 28. Mr. Bature Peter. 29. Mr. Suberu Aminu O. And Mr. Ojo Olagoke. 32. Mr. Annie Wale B. 33. Mrs. Omoro Amina. 34. Mr. Awe Oluwasami B. 35. Mr. Ego Okon. 36. Mr. Ola Caleb. And 1. Federal Cooperative College, Ibadan. 2. Federal Ministry of Agriculture and Rural Development. 3. Federal Civil Service.
Yeah, I was trying to say your present. Please come and sit here.
Parties absent, right?
Federal Cooperative College is present.
Parties present, my lord.
First defendant present.
Claimants are in court, my lord.
Parties absent.
Claimants are in court, my lord. Some of the claimants are in court. Please, claimants, come forward, let my lord see you. Please, claimants, come forward, let my lord see you. Yeah. Claimants are in court, my lord.
Okay.
Claimants, come forward, let my lord see you.
Okay, what of the defendant?
My lord, the first defendant is present.
Yeah, you can go and have your seat.
Where is he?
Is represented
by who?
Idigbe Friday, admin officer.
Idigbe Friday, admin officer.
Let me see him.
This is him. I can't even hear anything. What? Has she said anything?
That's the day.
This is Idigbe Friday, my lord.
Idigbe Friday, admin officer.
Hello. Okay.
My lord, Idigbe Friday is
okay. Who is representing the second defendant? Okay, I've noted that. Who is representing the second defendant? The second defendant absent?
Second defendant.
Second and third
absent.
defendant, are they absent?
They are not in court, my lord.
They are not in court, my lord. Yes, my lord.
Okay. Yes, counsel now. Counsel.
With the greatest respect to your lordship, my name is Wasiu Oteniara. Yes, my lord. My lord, I announce my presence for all the claimants in this matter. I'm much obliged to your lordship.
Yes. Who is for the first defendant? Counsel for the first defendant.
Counsel for the first defendant is already on his feet. It's on his feet, my lord.
Yes, I'm not hearing her. What's the name?
With respect to this honorable court, C.A. Bozimo, holding the brief of F.J. Edema for the first defendant.
Are you Miss or Mrs.?
Miss, my lord.
Holding the brief of who?
F.J. Edema.
For the first defendant.
Yes, my
Bozimo, you are for the first defendant, right? Okay. Who is for the second defendant?
Counsel not in court, my lord.
Counsel to the second defendant, not in court.
Not in court, my lord.
Who is for the third defendant?
Counsel also not in court, my lord.
With most humility. I'm present here. I'm in court. With most humility, my lord. R.M. Olushono.
Miss or Mrs.?
Yes, my lord. For the third defendant, with humility, my lord.
Is she saying anything? I don't know, maybe it's network.
Can you all hear me now?
Yes, my Lord. Yes, my
Yes,
Lord.
my
I can
lord.
hear you.
Okay. I want to read the judgment now. In order not to waste time, I will skip all the summary of your pleadings, your argument. I'll just read out your claims as endorsed and issues as framed in your final written addresses, and then go to the decision part. But when you pick your copies of your judgment, you see all the summaries there. We agree on that?
Yes, my Lord.
Yes, my lord.
Okay. Court judgment. This case was initially filed before the Federal High Court Ibadan and was transferred to this court on 30th of October 2012. By the amended statement of facts, the claimants are seeking for the following release from the defendant. One, a declaimant and pensionable staff of the first defendant, that's the Federal Cooperative College Ibadan, and that their employment has statutory flavor subsequent upon their conditions of service, including being contained in the regulation and act and statutory provisions, that is the public. Two, a declaration that the purported termination of claimants by the first defendant via letters signed by the first defendant at various times, being contrary to contract of employment, and that. Three, another for payment of mandatory pension fund deductions and health insurance deductions made from the claimant into individual claimants' deducted pension fund and health insurance accounts. Four, another for payment to claimants all accrued and unpaid entitlements of salaries, bonuses, allowances, howsoever called, due to them since their purported termination by the first defendant till judgment is delivered in this suit. Five, another for reinstatement of the claimant into their employment with the first defendant or in the alternative. Six, another for the immediate payment to the claimant all their gratuities and other entitlements, including pensions and health insurance deductions from their individual period of purported termination of appointment till judgment is delivered in this case. In the final written address of the third defendant, its counsel formulated an issue for the determination of the court this way: whether the claimants have established any cause of action against the third defendant. Can you people give me a minute? Let's pause. About 3 pages are not properly printed. I'll sit down here and then they'll bring the printer and my computer. Are we good with that?
As the
As the
court
court pleases.
pleases.
Counsel
As the court pleases.
As the court pleases.
and the printer. Yes. Sorry about that. Call call the secretary for me. Don, to bring the printer in my office and my laptop. I've seen page 5. The second defendant's final written address. Counsel to the second defendant formulated these 2 issues for the determination of the court in its final written. The totality of this case, vis-a-vis the evidence before the court, it could be reasonably held that the claimants were statutory staff of the fourth defendant, so as to be entitled to their relief sought, and 2, whether or not the claimants have successfully established second defendant in relation with their You need to move it in. Yes, move it here. Can we continue? Seven, 8, 9. Just on that. Can we continue now?
Yes, my lord.
Counsel? Okay.
Yes, my lord, we can continue.
To the first defendant from its final written address.
Yes, my lord.
Or where did we stop?
We stopped at the second defendant final written address.
And I read out the issue frame there. Do you want me to repeat that, or we go ahead to the first defendant? Because I'm only reading out the issue.
You are on the issues formulated by the second defendant.
Yes. So the next one is that of the first defendant. The next one is the first defendant's final written address. And counsel framed is issued this way: whether the claimants are entitled to their relief sought in view of the quality of evidence proffered and the document tendered, if any, in support of the claims before the court. Then I go to the final written address of the claimant's counsel. In the final written address of the claimant at page 1605, their counsel formulated 5 issues for the determination of the court this way. 1, whether considering the facts and evidence adduced and the state of the laws and equity as canvassed herein, claimants are not staff of the first and the second defendant, and by implication, federal civil rules, and whose employment enjoys or is clothed with statutory flavor. 2, whether the second defendant is not a necessary party to this suit, despite the fact of agency relationship existing between her as an officially disclosed principal and the first defendant, and consequently not vicariously liable for the liabilities, deeds, and actions of the first defendant. 3, whether the claimant, particularly the defendant, particularly the first and the second defendant, acted with diligence, due process, equity, fairness, and lawfully as employers of the claimant to avoid and or mitigate loss of status and financial remuneration to claimants in their employment. 4, whether claimants all employed under similar rules, status, and circumstances, and also disengaged under similar rules and circumstances, should be exposed and subjected to different and discriminatory procedures and conditions, resulting into some claimants' financial deprivations and negative fortunes at retirement. And 5, whether in the absence or withholding of direct evidence documentary, in proof of material facts of claimant, appointment, confirmation, promotion, and increased benefit and entitlement, the claimant cannot use circumstantial evidence strictly and conclusively as means of proving their case. I now go to the decision part of the judgment. I have carefully read through the fact of this case, the written argument of all counsel and their cited authorities, both statutory and decided ones. From all of this, I am of the considered view that the issues for the determination here are the following. 1, is the second defendant a necessary party in this case? What is the nexus between the first and the second defendant? What is the claimant's cause of action against the third defendant? Are the employment of the claimant with statutory flavor? 2, are the provisions of the Public Service Rules 2008 applicable to the case of the claimant? Are the claimant public or civil servants by virtue of document C1? Are they permanent and pensionable staff of the first defendant? Were pensions and insurance funds deducted from the claimant's salaries by the first defendant while they were in its employment? 3, was the termination of the employment of the claimant wrongful, contrary to the terms of their employment? And are they entitled to reinstatement or to payment of their gratuities and pensions? Before going into the merit of this case, I need to resolve some preliminary problems which arose from the parties' final written addresses. The first one is on the admissibility of document D1, D2, and D4. Counsel to the claimants raised objection to the admissibility of these 3 documents in paragraph 6.1.21 to 6.1.22 of his finding, the grants that the document. He went on that he went on and objected. Sorry. He objected because the defendant Council tendered their certified is during trial from the bar without 104 and 105 of the Evidence Act 2011. This Act to 1479A through the provisions of sections 104, and there is nothing there in request 10 certified true copies of this document at trial. However, issue of front-loading of documents is provided for in Order 30 of the National Industrial Court of Nigeria Civil Procedure Rules 2017. By Order 30 Rules 2 sub 1 sub D of these rules, the defendants who intend to defend shall at the trial, shall at the time of filing their document front-load copies of the document they are relying on at trial. In this particular instance, the claimants are not challenging the authenticity of this document, neither are they objecting to the forms of the document. Therefore, I hold that for challenging the admissibility of this, therefore the objection is overruled. I further hold that D1A, D2A, and were properly in this case.
As
I
the court pleases.
need you to respond. That will show me that you are hearing. Okay.
As the court pleases.
Additionally, document C. Thank you. Additionally, document C2 at page 70, at pages 760 to 766 is a table showing the number of the false defendants' employees entitled to health allowances. This document has no evidential value as it has no author, and it is accordingly discountenanced in this judgment. Can I hear a response from counsel, please?
As the court pleases.
Is the second defendant a necessary party? Thank you. Is the second defendant a necessary party in this case? And what is the nexus between the first and second defendant? The law is that a necessary party to a suit is one who is not only interested in the subject matter of the proceedings, but also one whose absence the proceedings will not be fairly dealt with. Consequently, without its being a party to the suit, the court God call them to bring battery. Call them to bring battery for this speaker. Without its being a party to the suit, the court may not be able to effectually and completely adjudicate and settle all questions involved in the case. Thus, a necessary party to a case is a person whose presence is required for the eventual and complete adjudication of questions involved in the case or matter. See Ojo versus Ogbe, citation supplied, and Mobile PLC versus DENR Limited, citation also supplied. While examining the claimant's letters of employment in document C3 at pages 1127 to 1178 of the record, I found that the first and second defendants participated in the employment of the claimant as the names of the two defendants are listed on the letterhead papers used in communicating the appointment to the claimant. Consequently, I hold that the second defendant is a necessary party whose presence is indispensable for the eventual and complete adjudication of all questions in this case. I further hold that the first and second defendant jointly issued the letter of employment of the claimants in this case, and this is the nexus between the first and the second defendant. And I so hold. Is there any cause of action established by the claimant against the third defendant? The argument of the third defendant is that the claimants have no cause of action against it and urge the court to dismiss this case against it, the commission. In paragraph 6 of the amended statement of fact, the claimant deposed inter alia that they were employed at different points in time between 1994 and 2003 as staff of the first defendant with the approval, consent, and directive of the second and third defendant. Also in paragraph 21 of the same process, the claimant deposed that the second and third defendants had approved the promotion of some of them, which the first defendant never implemented. See also paragraphs 8 and 25 of the written statement on oath of CW1 Adeolu Taiwo for their evidence on these pleadings. In addition, by the content of document C4, which is the claimant's termination letters, jointly so marked at pages 1080 to 1234, particularly at pages 1191, 1195, 1197, 1199, 1202, 1207, 1210, 1225, and 1226 of the record. The third defendant prepared the severance packages of some of the claimants. With all these facts and evidence before the court, I find an oath that the claimant has cause of action against the third defendant in this case. I again hold that the third defendant is a proper party in this case.
As the court will.
Okay. Is the employment relationship between the parties that of master and servant or one with statutory flavor? It is tried that the mere fact that an employer is a creation of statute, a statutory corporation, or that government has shares in it does not elevate such employment to one with statutory flavor. A contractual relationship is said to have a statutory flavor if that relationship was created and governed by statute or regulation derived from a statute. So that valid determination of the appointment or is predicted on satisfying such statutory provisions. See Inyaye versus UBTH Management Board, citation supplied. See NEPA versus Adesaji, citation also supplied. The recruitment budget of the first defendant, the recurrent budget of the first defendant for the years 2005 and 2006 as exhibited in documents C8 and C8A at pages 1068 to 1078 of the court record, together with the 2005 and 2004 nominal rolls of the first defendant at pages 1079 to 1086 of the record, do not by any imagination establish that the claimant's employment with the defendant were with statutory flavor. Neither do they substantiate the fact that the claimants were confirmed as permanent and pensionable employees of the defendant. These status can only be statutorily given to the claimant by following certain procedures, and I so hold. Are the provisions of the Public Service Rules 2008 applicable to the claimant's case? The claimant's contention is that their employment were with statutory flavor, relying heavily on document C6, which is the Public Service Rules 2008. However, from the evidence before the court on this case, the claimant's employment were determined in different years. Some were determined in 2005, some in 2007, and others in 2006, and others in 2007, respectively. See document C4 at pages 1180 to 1234 of the record. The Public Service Rules 2008 is document C6, and it was gazetted on August 25, 2009. It is not stated that these rules have retrospective effect. It is therefore my findings that document C6, which is the Public Service Rules 2008, do not have any retrospective effect. In the circumstance, I hold that document C6 is not applicable to the claimant's case that was filed on June 26, 2007. See pages 5 and 8 of the record. Aside from document C6, the claimant did not refer the court to any law, statute, rules, or regulations which created or governed their employment relationship with the defendant, from which the court can decide the validity or otherwise of the determination of their employment, or whether or not such or that such determination depends on satisfying the provisions of such statute, rules, or regulations. Furthermore, the claimant's appointment letters are jointly marked as document C3 before the court, and they are at pages 1127 to 1178 of the record. The letters of appointment of the 1st, 2nd, 7th, 10th, 12th, 13th, 13th to 16th, 18th, 19th, 24th to 26th, 29 to 33, and 35 states that the appointments are temporary. Those of the 3rd, 6th, 11th to 13th are described their appointment in the letters of the remaining claimants. Fine, please. Okay. Thank you. In the letters of the 8th, 9th, 21st, 27th, 28th, 33rd, 33rd, 34th, and 36th, just state the positions given to them without indicating whether they are casual or temporary staff of the first defendant. Therefore, I find nothing in these letters to show that their employment are with statutory flavor. The mere fact that the claimant's employment are the mere fact that the claimant's employers are agencies creation of statutory provisions, or the government, or that the government has shares in them, does not elevate the claimant's employment to that of having statutory flavor. In the absence of any authority in support of the claimant's contention that the employment are with statutory flavor, I hold that the employment of the claimant with the defendant are not with statutory flavor. I again hold that the employment relationship between the parties in this case is a private one, otherwise known as master and servant relationship. Are the claimant public or civil servant by document C1? Council the public servants of the Federal Republic of Nigeria by virtue of the approval already given in document C1. This document is at page 759 of the court record, and it is Federal Ministry of Agriculture and Rural Development, Area 11, Gariki, Abuja, reference number NR 320/S2S.2/113, 22 January 2004. Director, Cooperative Department, Federal Ministry of Agriculture and Rural Development, Area 11, Abuja, Gariki, Abuja. Title, Absorption of casual workers into permanent pensionable appointments. I'm still quoting, I am directed to inform you that arising from the deliberations of the Committee of the Directors of this Ministry at its meeting of 8th of January 2004 on the above subject matter, the permanent secretary sought from the head of the Federation for the absorption of some casual workers of this ministry, including some put forward by your department. This is in compliance with HOCSF circular number HCFS/186/3 of 11th October 1999. 2, as paragraph 2, to ensure full compliance with the procedure set out in the said circular for seeking the necessary waiver, I am to request you to forward the underlisted 1, approved establishment for your department for year 2003, showing clearly unfilled vacancies in respect of the position for which absorption is being sought. 2, present staff strength of your department for wanting the vacancies filled. The posts have become absolutely necessary. Paragraph attached the list of positions presented to the permanent secretary to be filled in your department. Paragraph 4, your early response will be appreciated, please. Signed, Uku Benyije, for Director, Administration and Supply, end of quotation. By way of reminder, the first defendant in this case is Federal Cooperative College, Ibadan. The second defendant is the Federal Ministry of Agriculture and Rural Development, while the third defendant is the Federal Civil Service Commission. The content of document C1 is a correspondence within a department of the second defendant. It is a deliberation on how to absorb some casual workers into the permanent pensionable appointment by seeking for waiver from the head of service of the Federation in compliance with 1 HOCS circular number HCSF/186/3 of 11th October 1999. Paragraph 2 of this document C1 states further directive on how to comply with the said circular on absorbing the casual workers. From the content of document C1 reproduced above, there is no approval given, and there is nothing in it to suggest that the employment of the claimant are raised to public servant status. Consequently, I find and know that the claimants are not public servants. Neither are the status of their employment with the defendant raised to permanent and pensionable ones by the content of this document. were the pension and health insurance funds deducted from the claimant's salaries by the first defendant while they were in its employment? In their relief 3 endorsed on the complaint, the claimant are seeking for an order of the court for payment of pension fund deductions and health insurance deductions made from the claimant in their individual dedicated pension fund and health insurance account. In support of this claim, they relied on the letter issued to them by legacy pension Managers Limited, as document C5 to 1275. Yes, Council. Where did you stop? Or what did you hear last? May I know where you stopped hearing me? At what point did you stop hearing me? At what point?
I can't hear you.
Okay, let me just take that topic again. Were the pensions and health insurance fund deducted from the claimant's salaries by the first defendant, right? That's the issue we are resolving when the internet is connected. Can I go on, please? Can I go on? Why is it not talking again? Okay, wave to me. Can I go on or stop? Are you hearing me now? Yes or no? Okay. In their relief 3 endorsed on the complaint, the claimants are seeking for an order of the court for payment and health insurance deductions made from the claimants into their individual dedicated pension fund and health insurance account. In support of this claim, on the letters issued to them by Legacy Pension Managers Limited, marked as document C5 in this case, and they are pages 1235 to 1276 of the record. These letters merely show that the claimant opened the said account, set their account number, their PIN, and their PIN. There is no evidence that the false defendant deducted any sum of money from any of the claimants, either for pension or health insurance before the court. The law is that he who asserts must prove. See Kafaru versus Reliance Telecommunication Limited, citation supplied. The claimants who are saying that the false defendant made some deductions from their salaries are required in law to prove that the deductions and to prove that deduction, and they fail to prove same in this case. Consequently, I find a note that the false defendant did not make any deduction for pension and health insurance from the claimant's salary while they were in its employment. Was the termination of employment of the claimant wrongful and contrary to the terms of their employment? Relief 2 of the claimant as endorsed is for the declaration that the termination of employment by the false defendant at various times was irregular, wrongful, discriminatory, null and void, and contrary to the contract of employment. The position of the law is that an employee who complains that he was wrongly terminated has the onus to place before the court the terms and conditions of his contract of employment and to prove the way and manner those terms were breached by the employer. It is not the duty of the employer, who is a defendant, to the employee's action to prove such breach. See the case of West African Examination Council versus Oshinebo, citation supplies. In the instant case, I found that the claimants have not proved their terms and conditions of employment to the satisfaction of the court, because I have held above in this judgment that the public service rules, which they relied on, that public service rule 2008, document C6, which the claimant heavily relied on as the terms and conditions of their employment are not applicable to them. To declare that the termination of the claimant's employment by the false defendant at various times was irregular, wrongful, regular, wrongful, and null and void, and contrary to their contract of employment. Are the claimants entitled to reinstatement of payment of gratuities? In their reliefs 4, 5, and 6, endorsed on their complaint, the claimants are seeking for orders of reinstatement to their positions with the false defendant, payment of all their accrued and unpaid salaries, bonuses, and allowances from when their appointment was terminated until judgment is delivered in this suit. In the alternative, they are seeking for an order for payment of all their gratuities. I have held above that the claimant's employment are not with statutory flavor. And so, even if the termination of the claimant is wrongful, they will not still be entitled to reinstatement. In this particular instance, the claimant failed to prove to the court how their employment was wrongly terminated, and so the said termination of employment cannot be faulted by this court, and I so hold. Conversely, I hold that the termination of the claimant's employment by the defendant is proper. As a result, I hold further that the claimants are neither entitled to reinstatement nor gratuity in this case. Accordingly, reliefs 4, 5, and 6 of the claimants lacked merit, and they are hereby dismissed. Are there justifiable reasons for the defendant to pay severance benefit to some of the claimants without paying to others? Issues 3 and 4 framed by the claimant counsel in his final written address are to the effect that this court is to decide whether the first and second defendant acted with diligence, equity, fairness, and lawfully in mitigating the financial challenges of the claimants when their employment were terminated by paying severance benefits to some of the claimants while others were not so paid, even though their employment were determined under similar situations without cogent reasons. See argument of the claimants counsel on this issue in paragraphs 6.3 to 6.4.10 of the final written address. The letters of termination of all the claimants are jointly marked as document C4 in this case, and they are at pages 1180 to 1234 of the record. From the content of these letters, the names of the following 8 claimants were forwarded by the Bureau for Public Service Reforms, BPSR, to the third defendant, that's the Federal Civil Service Commission, for termination of their appointment and for payment of their severance benefits. They are the 12th, 13th, 14th, 15th, 16th, 18th, 19th, and 31st claimants. However, the names of the other remaining 21 claimants whose employment were terminated alongside these 8 claimants paid severance benefits were not paid any severance benefit, and no reason was given for this denial. The 21 claimants so affected are the 1st, 2nd, 3rd, 9th, 11th, 20th, 21st, 22nd, 25th, 26th, 27th, 28th, 29th, 30th, 32nd, 35th, and 36th claimants, because their names were not forwarded by the Bureau for Public Service Reform to the third defendant, whereas all the claimants were in this in the same bracket category and status at recruitment, during service, and at separation. Counsel to the 1st, 2nd, and 3rd defendant did not respond to this issue. In the absence of any challenge to the issue of discrimination in payment of severance benefits from the defendant counsel in this case, it is deemed that the defendants admit that they have no excuse for such discrimination against the 21 remaining claimants who were not paid any severance benefits. See the case of Balo versus FRN, citation supplied, in which our lordship, orderly GSC, heard at pages 42 to 43 that it is well settled that fact admitted need no further proof. In the circumstance, I hold and declare that the 1st, 2nd, and 3rd defendant unjustifiably discriminated against the remaining 23 claimants. However, the claimants did not supply the parameter for calculating the severance benefit entitled to by these 21 remaining claimants. Therefore, I decline from ordering or directing the defendant to pay the said severance benefits to them. The employment of the 33rd claimant was not terminated. See affidavit at page 1231 of the record. Apparently, she was retired, but she is still listed among those terminated by the claimant. Furthermore, the termination letters of the 7th, 8th, 17th, 23rd, 24th, and 34th claimants are not included in document C4. And so this court has no basis for deciding whether they were paid severance benefits or not, and I so hold. On the whole, I hold and declare as follows. 1, I hold that the second defendant is a necessary party in this case. 2, I hold that the nexus between the first and second defendant is that they jointly employed the claimant. 3, I hold that the claimants have cause of action against the third defendant, and so the third defendant is a proper party in this case. 4, I hold and declare that the employment of the claimant with the defendant are not with statutory flavor. 5, I hold and declare that the provisions of the Public Service Rules 2008 are not applicable to the case of the claimant. 6, I hold and declare that the claimants are not public or civil servants by virtue of the content of document C1. 7, I hold and declare that the claimants were not permanent and pensionable staff / employees of the first defendant. 8, I hold and declare that the first defendant did not deduct any fund for pension or health insurance from the claimant's salaries while they were in its employment. 9, I hold that the termination of employment of the claimant were proper. 10, I hold and declare that the claimants are not entitled to payment of gratuity and pensions. 11, I hold and declare that the defendant unjustifiably discriminated against the remaining 21 claimants by not paying them severance benefits like they did to their other counterparts, so paid without any reason. And 12, I hold and declare that because the claimant did not supply the parameter for calculating the severance benefit of this 21 claimants, I decline from ordering or directing the defendants to pay them the said severance benefit. Judgment is entered accordingly, and I make no order as to cost.
As the court pleases. As the court pleases.
So if the Korea people will be fast, you get your copies of judgment this week or latest next week by God's grace. But it will leave my table latest by tomorrow, by the grace of God.
As the court pleases.
Thank you.
As the court pleases. We are grateful to my Lord for a well-considered judgment. Thank you, my Lord.
Who is talking?
The first defendant counsel.
Tell me your name again.
C.A. Bozimo.
Okay.
Holding the brief of F.J. Edema.
No, Bozimo is okay.
As the court pleases.
You have said that one before.
My Lord. We counsel pick the judgment from the
Who's that?
NIC. First defendant counsel.
You said?
I said we counsel pick the judgment.
Third defendant counsel.
First defendant counsel. First defendant counsel.
Okay.
I want to ask. We counsel pick the judgment from NIC or it will be delivered to their offices.
You said what?
I said we counsel pick the judgment from the NIC Ibadan or it will be delivered to their offices.
No, we'll send it to Ibadan. We will send it. Who is this talking to me? Mrs.
Defendant.
Solution. That's Miss
First
Solution.
Defendant Counsel. No, Miss Bozimo.
Oh, okay, okay. Okay, you pick it in Ibadan.
Okay,
it will get to Ibadan latest next week by God's grace.
As God pleases. We are grateful, my Lord.
Okay. Okay. So, Oteniara, Mr. Oteniara. And Olushola, they did not teach you to appreciate court when the court gives judgment or what? That's the end of the proceedings.
As the court pleases.